Nation-centered power gives greater authority and responsibility to the federal government. Generally speaking, nation-centered powers are limited to those specified in the Constitution. As it relates to black politics, the so-called Reconstruction Amendments that were introduced into the Constitution after the Civil War are probably the most significant. These are the 13th, 14th, and 15th Amendments to the Constitution. The 13th Amendment stated, in part, that neither slavery nor involuntary servitude shall exist in the United States. But significantly, it goes on to say, except as punishment for a crime. Thus, the formal institution of slavery was effectively abolished, but many states found ways of maintaining control over black bodies and black labor by essentially criminalizing blackness, subjecting newly freed men and women to constitutionally sanctioned involuntary servitude. The 14th Amendment of the Constitution ostensibly provided citizenship for former slaves and equal treatment under the law. The 15th Amendment provides that the right to vote shall not be abridged on account of race, national origin, creed, color, or previous condition of servitude. I give a much more detailed assessment of the limitations of the 13th, 14th, and 15th Amendments of the Constitution in a separate video, so for more on that, check out my previous episode by clicking the link below. For the purpose of this discussion, however, it would suffice to say that although the Reconstruction Amendments are specifically designated in the Constitution and thus apply to all of the states of the Union, their effectiveness is largely limited to the degree to which states have the flexibility in terms of how the spirit of these constitutional revisions are implemented. The New Deal programs also greatly expanded the reach of the federal government. In the 1930s, the economic catastrophe known as the Great Depression proved to be a disaster that the states themselves were ill-equipped to deal with. Largely due to the power granted to the federal government by the Interstate Commerce Clause in the Constitution, the Roosevelt administration embarked on an extensive series of programmatic efforts to stimulate the economy. Such efforts included rebuilding and revitalizing interstate highways and other infrastructure projects, as well as placing regulations on the banking industry and implementing public assistance programs such as Social Security, among many other programs. Here again, the effectiveness of these programs at meeting the needs of black Americans was often a function of how the individual states implemented them. Outside of that, the Great Society Initiative, launched by President Lyndon B. Johnson in 1964 and 1965, was a programmatic effort to attack and eliminate systemic poverty, as well as racial injustice. As part of the agenda, the War on Poverty expanded many of the New Deal programs guaranteeing assistance to the poor that were initiated during the New Deal in the 1930s. In 1964, Johnson signed the Civil Rights Act, which banned discrimination in public accommodations, schools, parks, and playgrounds, as well as banning discrimination in employment. The landmark legislation also established new powers for the U.S. Attorney General and a new Equal Employment Opportunity Commission to oversee discrimination in government agencies, which have historically been a major employer of African Americans. You may recall that one of the ways in which the Civil Rights Act was implemented was in the wake of the Rodney King verdict. On March 14, 1991, the Los Angeles District Attorney charged officers Kuhn, Powell, Briceño, and Wind with excessive force under the jurisdiction of the state of California. On April 29, 1992, the jury acquitted 3 of the officers, but could not agree on one of the charges against Powell, in a ruling that sparked the 1992 Los Angeles uprising. Subsequently, however, 4 of the officers were tried in federal district court for violation of King's civil rights. The trial ended on April 16, 1993, with 2 of the 4 officers being found guilty and subsequently imprisoned. In 1965, President Lyndon B. Johnson signed into law the Voting Rights Act. Because voting rights were codified in the 15th Amendment of the Constitution, the power of the federal government to limit the state's ability to implement restrictions on voting rights was sanctioned in the U.S. Constitution. Thus, the Voting Rights Act was applicable to each state in the Union. The Act contained a number of provisions intended to protect the voting rights of U.S. citizens, particularly African Americans. The legislation placed a general restriction on imposing any law that results in voter discrimination, specifically naming literacy tests and other methods that have been historically used as a pretext to keep African Americans out of the voting booth. Additionally, however, the Act contains a special provision that applied with certain jurisdictions with a history of discrimination. Most significantly, Section 5, the pre-clearance requirement, prohibited mainly Southern jurisdictions from implementing any change to voting rules or qualifications without receiving pre-approval from the U.S. Attorney General or the U.S. District Court of D.C. The purpose was to ensure that such changes would not discriminate against protected minorities. As a result, many attempts to change voting districts or establish new rules, such as voting ID requirements, were held at bay until the U.S. Supreme Court decision in Shelby County v. Holder in 2013. That decision struck down Section 5 of the Voting Rights Act. In the wake of the Supreme Court decision, it took the state of Texas all of 2 hours to begin implementing voting ID requirements and a plan to remap the voting districts that had been blocked only the previous year as a result of the pre-clearance rule. Herein lies a perfect example of what happens when you leave such measures up to the states. The types of ID laws deemed acceptable by the state of Texas were clearly discriminatory. Concealed carry permits, for example, were considered acceptable forms of identification, whereas government employee IDs and other public university IDs, which are more often carried by people of color, somehow didn't seem to make the list of acceptable IDs. Since 2011, when Texas first began attempting to implement restrictive voter ID laws, 5 times the courts have ruled the ID law discriminatory, even after the pre-clearance requirement had been struck down. So, strategically, which would be a preferable route for implementing universal political change? A nation-centered approach or a state-centered approach? The answer depends on a number of factors, including the particular issue and the climate. Historically, the most expeditious approach has been the nation-centered approach. The 13th, 14th, and 15th Amendments to the Constitution, for example, set universal laws with regard to citizenship and voting rights that were limited significantly to the degree to which states were able to manipulate their way around them. Additionally, the degree to which those states could restrict the citizenship and voting rights of African Americans has been limited by the federal action, such as the Civil Rights Act of 1964 and the Voting Rights Act of 1965. Additionally, the Brown v. Board of Education ruling rendered by the Supreme Court in 1954 made Southern efforts to circumvent the 14th Amendment by way of Jim Crow segregation unconstitutional. Still, states have shown extraordinary resolve when it comes to finding ways to circumvent many of those rulings and federal actions. Also, nation-centered power hasn't been without its liabilities. It was the U.S. Constitution, as originally ratified in 1788, that sanctioned fugitive slave laws, the continuance of the international slave trade, and the representation system that rigged the House of Representations and the Electoral College heavily in favor of Southern slave owners due to the 3/5 Clause. As a result of the 3/5 Clause, which gave extra representatives to Southern states, counting 3/5 of the slave population for purposes of representation, Southerners elected 4 out of the first 5 U.S. presidents. It has been calculated that Southern seats in the House of Representatives has been boosted by an average of 25% until the 3/5 Clause was effectively abolished as a result of the 14th Amendment. National Supreme Court rulings that have limited African American efforts toward freedom and equality have included the infamous Dred Scott decision of 1857. The case was based on Dred Scott's claim that he had lived in Wisconsin Territory, a free territory, with his owner for over a decade. Because the slave owner brought Dred Scott to Wisconsin Territory, the fugitive slave law didn't apply. Since Dred Scott was not a fugitive or a runaway, he asserted that he had no obligation to return to the South upon the death of his slave owner. The case ensued when the slave owner's daughter pressed claims of ownership. The Supreme Court rejected Dred Scott's claim. In the Dred Scott decision written by Chief Justice Roger Taney, the court ruled that African Americans were not brought to the United States to be citizens, could not enjoy the rights of citizens, including the right to sue in court, notwithstanding free status, and had no rights that whites were bound to respect. While the Supreme Court decision in Brown v. Board of Education in 1954 declared segregation unconstitutional, that case overturned a previous decision from 1896 that sanctioned segregation throughout the land. The Plessy v. Ferguson decision centered around a case in which Homer Plessy sued for violation of his civil rights after having purchased a first-class ticket on the East Louisiana Railroad. The case was intentionally set up to challenge Louisiana's separate car law that required segregation of passenger trains by race. Plessy, who was phenotypically white, was subject to segregation by the law, which prescribed separate accommodations for persons described as octoroons, being at least 1/8 black. The decision constitutionally sanctioned and codified the Jim Crow regime based on the fallacious notion of separate but equal. On the other side of the coin, state-centered remedies as an approach for pursuing universal freedom have historically been rather cumbersome. The struggle for voting rights is probably the best example. As we discussed previously, Southern states in particular have tended to seek diabolically creative ways to restrict the voting rights of African Americans. With regard to voting rights for former felons, however, we have 50 different states with pretty much 50 different sets of rules as to how and under what circumstances persons with felony convictions may exercise their right to vote. Those circumstances range from Vermont and Maine on one side of the spectrum, where persons who are currently serving time in prison on felony convictions can actually vote from prison. On the other extreme, states like Florida, Iowa, and Kentucky apply a lifetime ban for all persons convicted of felony offenses, even after their sentences have been served. Throughout the rest of the Union, there's a whole range of different ways in which states have determined the voting status of persons with felony convictions. There's California, in which the right to vote is pretty much automatically restored once the sentence has been completed, to Mississippi, in which permanent disenfranchisement depends on the particular crime that the person was convicted of. Obviously, trying to get 50 different states with 50 different rules to agree on any specific policy regarding felon disenfranchisement would be cumbersome to say the least. That would likely be a situation in which a constitutional amendment or perhaps an act of Congress to universalize those set of rules would be more expedient. That approach, of course, depends on the type of Congress you have and if you have a president willing to sign such an act into law. On the other hand, as we've seen with the issue of marijuana decriminalization, the state-by-state strategy has proven somewhat effective. Another issue in which the state-by-state strategy may prove effective is on the abolition of the death penalty. The Constitution places a ban on cruel and unusual punishment. The strategy from many in the anti-death penalty advocacy centers on the unusual part of the cruel and unusual clause. In other words, there are 31 states where the death penalty is currently implemented. Although 4 of them, Colorado, Pennsylvania, Washington, and Oregon, there's a current moratorium as a result of state gubernatorial ban. In 19 states, the death penalty has been abolished. If you add the 4 states that are currently under gubernatorial ban, it only takes 3 more states to reach a critical threshold. If the anti-death penalty movement can attain the abolition of the death penalty in 26 states out of 50, a legal case can be made that since the majority of the states don't uphold capital punishment, the death penalty would then constitute unusual punishment. So, on the whole, nation-centered power has led to greater universal freedom for African Americans, with some important exceptions. State-centered power has tended to lead to restrictions on African American freedoms, but in certain situations, depending upon the state and depending upon the issue, state-centered power can be used as a vehicle to drive change on the national level. In what issues would you like to see political change? Which approach would be the most practical in achieving that change? I'd love to see your insights on the comments below. As always, if you'd like to see more of this content, please hit the like button. Until next time, I'm Darius Spearman. Thank you for watching African Elements.